Mr. Yeanoplos, you testified that the scope of your work consisted of performing a calculation engagement as defined in VS100. Mr. Yeanoplos, have you rendered an opinion of value in this court? Oh, and by the way, have you rendered that opinion to a reasonable degree of certainty?
I'm glad you teed that up for me. Your Honor, there is nothing in our professional standards that says I cannot do a calculation of value for litigation.
Stop there. That is a true statement. Continue. I want to parse your comments so that the audience fully appreciates it. That was a true statement.
Right. Now, we're outside of the courtroom. I can do it. Should I do it? The should I do it is a different. And Harold and I we've spent days, weeks discussing this. And the reality is, we actually are very close. He doesn't realize this, but we're very close to thinking the same thing. I tend to think that there are no absolutes. There are no absolutes. So to say always, never, that doesn't work in life. It doesn't work in any of the work we do. My calculations are very thorough. So in my calculations, do I look at the industry? Yes. Do I look at the need for normalizing adjustments? Yes. I mean, you go right down the line. My calculations are very thorough. So how are they different? Number one, the report is shorter. Number two, maybe I only do the income approach. And 999,000 times out of a million, I'm not going to use the market approach in litigation anyway. So I basically have something that I feel is adequate, and I feel like it gives me, I don't like that reasonable certainty. That is like my least favorite. I like that even less than the Texas Rangers.
Let's stop there. We're going off on a tangent. So, couple.
They knew what I was saying.
Couple of thoughts here. Mr. Yeanoplos, if you turn to VS100, doesn't it say that a calculation engagement is limited? And had you performed a valuation engagement, your results could have been materially different. Does it not say that?
It does say that.
So your results could have been materially different if you had done a valuation engagement. Let's just stop there. In addition, doesn't VS100 also say that you and the client have agreed mutually on the evaluation approach that is undertaken?
That is much ado about nothing.
Yeah.
Does it say that?
Yes, it does say that.
So you agree with your client how you're going to conduct your work?
Yeah, but this is how it goes.
Your Honor, may I
You
explain?
do that in every freaking engagement, right? You talk to the client. You tell them, here's how I'm going to do
Mr.
it.
Yeanoplos,
And the client says,
Mr.
okay.
Yeanoplos, let me ask you this question.
The
just
implication
in
is
summation,
what you're trying to do
Mr. Yeanoplos,
is
let me
make
ask
it
you this
seem like
question.
I'm not objecting.
Your Honor, would you please instruct the witness to listen to me?
Argumentative.
In a court of law, the standard to which you're held is issuing an opinion to a reasonable degree of certainty, is it not?
That's the stupidest thing I've ever heard.
He would never say that in
I was going to
court.
say, I'm not sure.
It is, by the way. Okay. So, Mr.
That's
Yeanoplos,
a legal term. It's not a...
if the standards say that if you had performed a valuation engagement, that the results could have been material different, how can you then say that you've rendered your opinion based on a calculation engagement, which is acknowledgedly and limited in scope, that you've issued an opinion to a reasonable degree of certainty?
I'm happy to answer that.
Please do so.
Notwithstanding the fact that the reasonable degree is the stupidest phrase ever.
He would not say that in court.
No. But I'm going to tell you how, in my particular situation, I have done steps to minimize the potential for a materially different answer. That's what I'm going to tell you.
All right, let's stop there. You get the idea. All right, he used the comment earlier that we agree. I'm hoping you get a sense now that that was sort of not true. Miles, would you like to comment on this?
Before Miles, would you just give me 15 seconds?
15 seconds.
To tell you when I have used a calculation in the courtroom. It's been with like a farmer's insurance agency where I have excellent comparables of the exact agency that is in question, and I can say historically this is what it sold for. The other thing is there's no expert on the other side. So,
Yeah.
well, what I'm telling you
Mr.
is
Yeanoplos, how is that remotely relevant?
it's relevant because there are situations where you can do it.
All right, let's stop there. Miles,
The key point to take away is the phrase to a reasonable degree of accounting certainty, whether you can insert business valuation, forensic accounting certainty. That is a magic bell that must be rung for expert witness testimony in any matter, primarily in medical malpractice cases. So judges are in tune to that, and that's what forms the basis of your opinion. So that's how it gets entered. So be comfortable with that phrase, and be comfortable saying, that's my opinion, and based on my professional judgment, I did this work and created this opinion. And here it is. So understand the core, and that this is a very esoteric exercise on the calculation versus pure valuation. But now what you do need to be prepared for tangentially is the standard of value argument. And that's where coming to these conferences is really helpful.
that's not going to come into play on this particular issue.
Yeah, but in general, there's always a discussion on standard of value.
Right.
And you've got to be able to answer those questions, because at some point during your career, you're going to get into an argument about the difference between fair value, fair market value, and my favorite, fair market value as adjusted by case law.
We got a whole other section.
I'll
on
shut up.
standard
Yeah, I was
value.
Miles,
done.
is there anything in our professional standards or literature where the term reasonable degree of accounting certainty is brought up?
I got a question on that too.
No.
I don't remember, the only place I've seen that is in the damages, lost profits stuff,
Yeah.
literature.
It's in the practice
It,
aids.
Seen that.
it is,
SSVS.
the term is not in SSVS, or it's now called VS100.
Right.
Right.
The term is not used in VS100. It talks about the scope of work and the type of opinion that it doesn't even use the word opinion. It says you are issuing a conclusion of value
Right.
or a calculated value. Those
Why
are the
we
two
saying
terms.
that reasonable degree of certainty applies to
Because that is the legal standard to which you're held as a testifying expert witness in the courtroom. That is defined in case law
Okay,
in most states.
got it.
All right.
And it's not defined because it's so basic. So you're never going to have...
It actually is defined. It depends on the venue and
No,
the state.
the dispute at the appellate level in the cases is going to be on standard of value, not the magic buzz phrase, because nobody ever argues over. That's the foundation for expert witness testimony, whether it be economic damages or this.
You're, if I understand you correctly, you're agreeing with what I
Yeah,
stated.
yeah,
Okay.
yeah.
Are
So
the magic buzzwords in fantasy land?
Kinda.
let me.
That's what the judge expects to hear.
I'm losing
at some
control
point
again.
during the testimony.
Gentlemen and ladies, let's close with this thought. Can you do it? Well, yes, you can pretty much do what you want. Should you do it? No. Okay. I will say this. The only time I have used a calculation of value in a litigation context is where I'm doing a phased approach. And I discussed the strategy with counsel beforehand. If there's an opportunity for a negotiated settlement, then the parties may agree that we'll use a limited scope calculation to save on fees. However, if settlement negotiations are not successful and we proceed to trial, then I reserve the right to expand my scope of my work to do a full scope valuation engagement so that I can satisfy that criteria. That's the only time I personally would do it. Again, can you do it? As Kevin said, yeah, you can. Should you do it? I would say no.